Decision podcasts by the New York Prosecutors Training Institute are made possible by Resemble AI. Convert your text to voice at resemble.ai. Find this and other decisions at NYPTI Law. www.nypti.org/law.
People v. Mitchell Hernandez, decided on February 18, 2025. Garcia, J. A person convicted of a violent felony offense is a persistent violent felony offender for sentencing purposes if that person has two or more predicate violent felony convictions. Penal Law Section 70.08, 1, A, B. Those potentially qualifying felony convictions must satisfy the timing requirements set forth in Penal Law Section 70.04, namely that the sentence on the prior crime must have been imposed not more than 10 years before the commission of the current felony. Penal Law Section 70.04, 1, B4. This 10-year look-back period is extended by any period of incarceration between commission of the prior felony and commission of the current felony. Penal Law Section 70.04, 1, B, V. Defendant challenges any extension of the 10-year look-back period using time he spent in pre-sentence incarceration on his earliest qualifying felony conviction. We now hold that pursuant to Penal Law Section 70.04, defendant's pre-sentence incarceration time did extend the 10-year period and therefore defendant was properly sentenced as a persistent violent felony offender. In 2015, defendant robbed a Manhattan convenience store at gunpoint and assaulted the proprietor. A jury convicted him of that robbery in 2017. Prior to sentencing, the people filed a predicate felony statement, CCPL 400.16, listing two prior violent felony convictions, the dates of conviction and sentence on those crimes, and detailing the relevant dates of incarceration that extended the 10-year period described in Penal Law Section 70.04, 1, B4. For a first qualifying felony, the people asserted that defendant was convicted of first-degree robbery and first-degree burglary in April 1997 and was sentenced for those crimes in May 1997. According to the people, that conviction resulted from a home invasion where defendant forced his way into a Bronx apartment occupied by a woman and her two children and robbed and sexually assaulted the woman. The second qualifying felony was a May 1990 second-degree robbery conviction that stemmed from the robbery and assault of passengers on a New York City subway. Defendant was arrested for that crime in April of 1990, pleaded guilty the following month, and was then incarcerated beginning in January 1991, prior to his October 1991 sentencing. According to the people's calculations, defendant was incarcerated for nearly 14 years, 5,049 days, during the relevant period. See Penal Law Section 70.04, 1, B, V. When given the opportunity to controvert the people's statement at his sentencing hearing, CCPL 400.15, defendant did not challenge the people's account of his prior convictions or the amount of time spent incarcerated for each crime. Rather, he made a purely legal argument, namely the one he presses here, that under the terms of Penal Law Section 70.04, the time he served in pre-sentence incarceration for the 1990 felony should not be excluded from the 10-year look-back period. The parties agreed that if the period of pre-sentence incarceration did not factor into the calculation for determining persistent offender status, the sentence on the 1990 offense would be outside of the 10-year limitations period and the conviction could not serve as a predicate for a persistent violent felony offender sentence. Supreme Court held instead that under the plain language of the statute, the period of pre-sentence incarceration must be excluded, and the relevant look-back period told, and sentenced defendant as a persistent violent felony offender pursuant to Penal Law Section 70.08. After noting that defendant had a long history of violence and stood convicted of a particularly violent crime, the court imposed the minimum available sentence of 20 years to life in prison. The Appellate Division affirmed, agreeing that the period of pre-sentence incarceration on the 1990 conviction told the 10-year look-back period. A judge of this court granted leave to appeal and we now affirm. Repeat offender statutes are intended to deter recidivism by enhancing the punishments of those who, having been convicted of felonies, violate the norms of civil society and commit felonies again. People v. Walker. We are asked to interpret one of the statutes enacted by the legislature to accomplish that public safety goal, Penal Law Section 70.04, which establishes the 10-year look-back period and the method for extending that period. Where a statute is plain on its face, we need only apply it in accordance with its meaning. See People v. Toluto. The text at issue here is plain and the meaning clear. For a prior violent felony conviction to qualify as a predicate, except as provided in subparagraph V of this paragraph, Sentence must have been imposed not more than 10 years before commission of the felony of which the defendant presently stands convicted. Penal Law Section 70.04, 1, B4. The except as provided language expressly requires that the 10-year period be determined as set out in the subsequent subparagraph, which explains that, in calculating the 10-year period under subparagraph 4, any period of time during which the person was incarcerated for any reason between the time of commission of the previous felony and the time of commission of the present felony shall be excluded, and such 10-year period shall be extended by a period or periods equal to the time served under such incarceration. Penal Law Section 70.04, 1, B, V. The plain text of this subparagraph unambiguously requires that the 10-year look-back period be extended by any period of incarceration between the time of commission of the previous felony and the time of commission of the present felony, including any period of pre-sentence incarceration for the prior crime. That is, the first part of the phrase mandates that such time shall be excluded, and the second clause requires that the 10-year period be extended by that period of incarceration. Unsurprisingly, each department of the Appellate Division to consider the issue has concluded that Section 70.04 means what it says. See People v. Holman, People v. McEachern, People v. Cortez. Other statutes demonstrate that the legislature chooses this same formula when warranted. See CPL 500.10, 21, providing a 5-year look-back period to determine whether an individual qualifies for electronic monitoring and excluding periods of incarceration between the time of commission of the previous crime and commission of the present crime. Penal Law Section 240.75, 1, providing a 5-year look-back to determine whether an individual is guilty of an aggravated family offense and excluding periods of incarceration between the time of commission of the previous crime and commission of the present crime, and when it intends a different result, it makes that clear. See CPL 160.59, 5, providing a 10-year look-back for sealing criminal records from imposition of the sentence but with tolling for incarceration after conviction of the previous crime rather than the date of its commission. We cannot avoid the deliberate legislative choice made here by accepting defendant's invitation to rewrite the statute's reference to commission of the previous felony. Penal Law Section 70.04, 1, B, V, to read sentence imposed for that crime. See People v. Boston. There is no ambiguity in the text requiring resort to legislative history or interpretive aids for statutory construction. See Matter of Walsh v. New York State Comptroller. Nor may we manufacture an ambiguity in the service of a preferred policy goal. Defendant's argument that the United States Supreme Court's holding in Erlinger v. United States renders unconstitutional the recidivist sentencing regime is unpreserved. As a threshold matter, defendant did not contest his criminal history, including the relevant periods of incarceration, and therefore we need not consider whether, had he done so, preservation would otherwise be required. See People v. Cabrera. Accordingly, the order of the Appellate Division insofar as appealed from should be affirmed. Order insofar as appealed from affirmed. Opinion by Judge Garcia. Judges Singas, Canataro, Troutman and Genovese concur. Judge Rivera dissents in an opinion, in which Chief Judge Wilson concurs. Judge Halligan took no part. Decided February 18, 2025.
Decision podcasts by the New York Prosecutors Training Institute are made possible by Resemble AI. Convert your text to voice at resemble.ai. Find this and other decisions at NYPTI Law. www.nypti.org/law